Good afternoon, everybody. My name is Chris Justice, and I'm back again here today to join you all in answering hopefully as many questions as I possibly can. Anything related to employment situations, whether it's with respect to maybe a contract you're looking at, and kind of some language in there that you're curious about, or whether it's with respect to some issues you're facing while you're actually in the employment relationship itself, or perhaps as well some questions you may have on your way out of an employment relationship, or maybe with respect to a severance package that you received. So definitely do get your questions in. As I say, I'll do my best to answer as many as possible. I am from Samfiru Tumarkin's Toronto offices. And so a lot of the information and advice I'll be giving will primarily relate to Ontario-based law. But as I always also do at the beginning is talk about a few issues, some things that are commonly coming across my plate, some sort of popular questions or situations that arise. And right now, to start, it's going to be back to some of the stuff I was talking about in some previous episodes, and that has to do with when an employer is substantially reducing your hours, cutting your hours, by at least 10 to 20%, if not more. And as a result, cutting your pay as well. And a lot of people have been coming to me and asking me what their rights are, what their options are when they are faced with a company that's cutting back their hours. And I will say that if that is something that's happening to you, it's definitely a situation that you want to address sooner rather than later. And certainly before having any communication with your employer about what to do in the face of your hours being cut, always recommended that you get some legal advice so that, our firm can tell you essentially what needs to be said and when it needs to be said. Because normally when you're an employee and your hours are being reduced, you'll have an option of either agreeing to the changes or taking a stand and saying that is not a change you are comfortable with and something that represents a big sort of departure or difference from what you signed up to do or the terms of your employment in general. And if in fact your employer has made significant changes to the terms of your relationship without your consent, that could be very likely in the eyes of the law seen as a constructive dismissal. And if you have been constructively dismissed, you're going to be entitled to the same amount of severance as though you had been let go on a without cause basis. So don't think that you are stuck in a situation where your hours are being cut, that you have no options. You do, but you also need to act relatively quickly and not let something like that linger on. Otherwise, you may risk being seen as having condoned the change itself. And it'll be later harder for you to argue that you've been dismissed and fight for a severance package. But depending also on your circumstances, you could be owed a severance package worth up to 2 years, especially for those who have been somewhere for a very long time, who are maybe a little bit elder in their years and who have, relatively good paying jobs. So obviously something you want to check out if you're in that situation and figure out what your rights and options are at the very least. Another thing I wanted to talk about off the top of the show has to do with performance improvement plans. Now, this is also something that I see on a relatively common basis where somebody will be working for a company and then at some point they will be told that their performance is not up to par. And as a result, the company puts them on a performance improvement plan. And a lot of people come to me, having been put on a performance improvement plan, or a PIP, as we say, and they're under a great deal of stress and anxiety because they fear they're going to lose their job. They may question why they're even being criticized to begin with. A lot of times the criticisms may be completely unwarranted, and the mere fact that you're put on a PIP could be grounds for a constructive dismissal as well, which, as I said a second ago, will entitle you to the same amount of severance as though you'd been let go. But even where the criticisms are valid, you're going to want to make sure that there's nothing inaccurate or I guess, misleading about the company's decision to put you on that PIP. If, for example, there are criticisms that maybe aren't accurate or partially accurate or don't fully explain the context, you're going to want to make sure that your voice as an employee is heard, because your silence will be likely treated as though you've accepted the criticisms. Another situation arises with PIPs where you as an employee will be given a set of goals or objectives that you have to meet in a matter of maybe a few months. And those goals or objectives that the company is expecting you reach to could be unrealistic. And you could then be essentially in a situation where you're being set up to fail with no achievable or no realistic way of achieving those targets, which then could lead to the termination of your employment. So if you feel like you're being given unrealistic standards or goals as part of a performance improvement plan, you're also going to want to make your voice heard on that front. Because again, if you're silent, it may be seen as you agreeing and accepting those roles and or those standards that are being expected of you. And then if you fall short later on, that may give the company grounds to let you go. So you definitely want to push back. You want to put your concerns in writing. You want to keep a paper trail, a record of your objections to a performance improvement plan, so that later on, if you need to rely on it or if a lawyer gets involved, they're going to be able to look at those past communications. And there's going to be evidence that you disagreed with some or all of the performance improvement plan itself, which then, if the company is going to rely on it later, could make it more difficult for them to do so. Now, you are, of course, not going to be able to guarantee that your job will be kept or that you won't be let go. Companies are always going to have a general ability to terminate someone's employment as long as it's not for discriminatory reasons or in extreme bad faith. But the question will be whether or not you're owed severance. And I think the more that the company is able to rely on the performance improvement plan in terminating your employment, the greater of an argument it'll have to deny you severance, which is, again, why it's so important to make sure that your voice is heard. But just like in a scenario where an employer is cutting your hours or cutting your pay, you're going to still want to contact our firm so that you can get the advice you need in terms of how to best communicate with your employer, and whether also or not it makes sense for a lawyer to get involved earlier on in the situation or later. So I'll talk about a couple more topics that I planned on speaking about, but I want to just get quickly into some of the questions that are being asked. So I've got one question in from Carter on YouTube, and Carter is asking what the requirement is for an employer, a business, to hold their employees' jobs while they're on a sick leave, and whether or not this requirement or standard would be different in the case of a small business. So that's a good question, Carter. I know a lot of employees are on a sick leave or have taken a sick leave or a stress leave or some sort of leave of absence that's related to a medical condition or ability. And they do come to me a lot and ask, what the status of their job is while they're on that leave. Can their employer get rid of them while they're on a leave? Does an employer have to keep that person's position open forever until they come back from the sick leave? These are all good questions. And I think it will also depend on the size of the business. So, for example, if you are an employee who's on a sick leave and your employer is a very, very small operation, they're not going to necessarily be expected to keep your job open for as long of a period of time that, let's say, a larger corporation like Walmart or Amazon would. For a bigger business, there's usually a higher expectation that there can be an accommodation made. And it's not enough to simply have, an inconvenience or a burden on the company. The company really has to show that they go through undue hardship in accommodating someone's sick leave anymore or for a longer period of time. So the idea of undue hardship is a very high standard or threshold to meet. And what is considered undue hardship for a smaller business is likely going to be viewed, as I say, differently than what a larger business would have to undergo before it can meet that test. So there's no exact defined period of time that an employer has to keep somebody's job safe while on sick leave, and it could theoretically go into the several number of years territory. So it's not a matter necessarily of a week or months. Your employer may be obligated to keep your job open for a number of years before it has to, or at least before it has the ability to possibly let you go later on. And even when it does that, you're being let go, you then go back to what are your severance entitlements. If there's any idea that you're being let go specifically because of the sickness, that could potentially involve extra human rights damages as well. So it's a lot of hot water an employer can be in if they choose to go down a path of terminating someone while they're off on a sick leave, or changing the nature of their job while they're off on a sick leave, unless a lot of time has passed and they can, again, sort of prove that there's been this undue hardship placed on them. But having said that, Carter, or anyone for that matter, if you are on a sick leave and you're being told that your job is changing, or that you don't have a job, or you've been let go, or your employer is constantly asking you for updates on your ability to come back, you definitely want to give us a call, because there can be a whole number of issues that involve situations where people are off on sick leaves, whether it's during the leave itself or after at some point. I've got another question in from Art on YouTube, who's asking how vacation pay works if they've been let go, and wondering if they're owed a full 5 weeks of vacation if they were terminated last week. So, Art, that's a good question. I think a lot of people come to me and sort of confuse vacation pay with vacation time. So vacation time, of course, refers to the number of weeks, whether it's 2, 3, 4, 5 weeks, whatever your contract says, whatever number of weeks of vacation you're allowed to take. And normally, for I'd say most businesses, your ability to take vacation time will sort of increase as the year goes on. So, for example, if you've been given 4 weeks of vacation time in a given year, you may not necessarily be able to take all 4 weeks right up front in, say, January. Usually what you'll be able to do is maybe take a week or two, and as you work for the remainder of that year, you'll accrue more vacation time, and you'll have an ability to take it out at some point after that. Then, on the other hand, there's vacation pay, which is essentially could be 4%, 6%, 8%. Again, depends on a contract, but it's additional pay that's added to your paycheck on top of any base wages that you're owed. So let's say, for example, you make $50,000 a year and you're entitled to 4% vacation pay. Then if you earn $50,000 of income in that year, you should be getting at least 4% of those wages on top of the 50 in terms of your vacation pay. So vacation pay is tied directly to the time that you work and the wages that you earn. So some companies will pay your vacation pay every pay period, could be biweekly or monthly. Other companies will pay out your vacation pay at the end of the year and just give you an added lump sum payment there. So your vacation pay should be paid out every year. But depending on when you're terminated, let's say in Art's case, they're terminated at the end of February, and they work there for January and February in that year, then they should at the very least receive the vacation pay, again, the 4%, 6%, whatever it may be, on the wages earned for this year. So for those 2 months, you would receive your vacation pay, and then you would also receive a little bit of extra vacation pay in the context that you were terminated. You'll get some vacation pay over a certain number of weeks after that. So depending on how long you've been at the company, if you're let go at the end of February, you should get vacation pay probably on at least the first 2 months and likely another month or two on top of that. But there is a difference between vacation pay and vacation time. And so, as I say, a lot of people will confuse the two and say, I get 5 weeks of vacation. I was let go in February. I want them to pay me out 5 weeks of wages. That's not necessarily how it's going to work, because again, those two concepts are different. So thanks, Art, for the question. Because again, I know it's something that I come across a lot and have to sort of explain to people. So thanks again. I've got another question from Sylvie on YouTube. Sylvie is a senior and she's employed for 39 years as a laborer and worked her way up to an operator position. Sylvie's suffering from some health issues, and her accommodation needs in the workplace are being bent, or I guess they're giving difficulty for her to follow. And Sylvie's asking, what can she do? So Sylvie, again, another question relating to workplace accommodations from a health perspective. As I said before, if you are suffering from health issues and there's ability for your employer to accommodate those health issues and have you go back to doing what you were doing, just subject to those accommodations, then they are expected to do that. As I said earlier, up to the point of undue hardship. So if your accommodation needs, Sylvie, are being bent, or there's difficulty in them getting to follow those accommodations, the employer that is, there can be a failure to accommodate issue that the employer has to deal with. And it may require legal intervention to get the employer to understand that these accommodations need to be made. Again, assuming there's no difficulty or undue hardship, I should say, in setting up those accommodations, that is an expectation. And if an employer fails to accommodate an employee's situation when it should in its situation, then that could lead to severance being owed to that employee, not to mention potential human rights damages as well, because there's the involvement of health issues, which are protected under the Human Rights Code. So an employer who fails to accommodate an employee's situation not only risks having to pay that employee out a potentially large severance package, but also additional damages for bad faith due to its unwillingness to be reasonable and accommodate those restrictions. So that's a good question, Sylvie. Thanks for asking that. I've got another one in from Stephen on YouTube. Stephen's saying that they worked as a contractor for a number of years, and the employer they worked for decided not to renew their contract. And Stephen's asking whether or not there would be any severance owed as a result. And Stephen, the answer to that is quite likely yes. You would be owed severance. It will come down to each individual case, but a lot of times people will come to me and tell me that they are a quote unquote independent contractor or contractor of some sort for the employer. And their understanding is that they're not entitled to severance because their employer or even themselves consider themselves to be a contractor. And that's a common myth, a common misconception. If you are working as a contractor for an employer and your employment situation with that employer ends, maybe as a result of the contract not being renewed, do not assume that you're not owed any severance. And there's, as I say, a good likelihood that actually you would be considered an employee in the eyes of a law. And if your employer had you working for them for, say, 5 to 10 years and they don't renew the contract, then that could very easily be deemed to be a termination of an employee for which you would be owed, potentially upwards of 2 years of severance. So, Stephen, if you're in this situation, I definitely suggest you give us a call because you definitely don't want to walk away with nothing, with all that potential money on the table, especially if when you say you've worked for several years, that means, 5+, and also depending on the contract as always and how much money you're making, but there is some great potential there. So give us a shout. And that goes for anyone that may believe they are not an employee and that they're called something else. It's not important to get too fixed on the label itself. It's more important to focus on what your relationship with the employer actually was and whether or not it was one that's more like your standard employee-employer type setup versus a completely independent contractor type situation. But Stephen, thanks for your question as well. I've got another one in from Ned. Ned is asking, or rather saying, that their company was taken over by another company. Ned's continued to work, and he's asking whether or not the years of service with the previous company would be considered or factored in if the new company ever let him go. And yes, Ned, highly, highly likely in the vast majority of situations, the company that took over, that is sort of taken you on board, will be liable for the years of service with the previous company. I don't know if there's a contract you would have signed with the previous company that may talk about your years of service or seniority or previous tenure being included with the new company. That would be a good starting place to see if there's any reference to any of this in a contract. But yes, you would typically get those years counted for. And so if you work for a company, say for 5 years, and they get bought out by a new company, and then you join the new company or just sort of transition into working for that company for another 5, that you'd be viewed as, an in total 10-year employee, for which the new company would be on the hook for if they decided to terminate you. And of course, they didn't have any cause or anything. So thank you. Thanks, Ned, for your question. I've got another one in from Bubba on YouTube, who's saying where they work, they needed, is it Fowlers, and they signed papers saying if we don't get certified, we may have to pay it back. They have provided us with proper work so we can get certified. And Bubba's in the hand logging business, it seems like. Okay, so sorry, Bubba, let me just make sure I understand the question. So you signed papers saying that if you didn't get certified, you would have to pay back some portion to the employer. And you're asking whether or not you should be given proper work so you can get certified. Assuming that the only way to get certified is to be given work, I think the logic would follow, Bubba, that they need to give you some work in order to get certified, if that's their expectation. So I don't know if they are actually giving you work or not, Bubba. But if they are not giving you work, then it may also come down to these papers that you signed. I think it would be important to first have a review of those papers that you signed, because it seems like those papers are going to be very important to figuring out what expectations the company has and whether or not you're actually under any obligation to pay back money if you don't get certified. So, Bubba, this would be a question better left for you to contact us on and discuss with our team. We can gather some information, gather documents, and this goes for anyone who's thinking of calling our firm. If you have an issue, just be prepared to be asked to provide some documentation or some evidence that might relate to your situation. So I think that would be necessary first, Bubba. But it seems like you may be onto something if certification requires work and the employer is not giving you work when they said they would be giving you work, right? There could be a breach of contract on their end, which then could make it less likely that they will be able to have to require you to pay any monies back. But again, I would say give us a call. Let us take a look at those papers first, and then I think we could properly advise you and give you all your options at that point. I've got another question in from Barb on Facebook. Barb is asking what sort of regulations is an employer allowed to place on remote workers? So it's a good question, Barb. There are a number. I can definitely list off a few, especially seeing as how nowadays a lot of people are working remotely from home. From pretty much the onset of the pandemic throughout, there's definitely been a trend of that being increased a lot more. And I do get a lot of questions from people who are working remotely from home in terms of the types of control that their employer may have on them. So, and one issue that crops up a lot has to do with privacy. It has to do with employers essentially tracking the work of employees while they're at home. A lot of employers are concerned that their employees may not be as efficient working from home, or in any event, there may be a social media policy or privacy policy in place that specifically speaks to the employer's ability to track potentially a laptop or cell phone. And actually, there was certain laws that came in that have now required employers to provide employees with written policies regarding these types of issues in terms of tracking software or any other sort of ways that the company is trying to monitor its employees. A lot of employees think that they shouldn't be able to do this, that this is a privacy concern. But the fact of the matter is that companies are, and have for that matter for a while now, able to track employees to the extent that it's appropriate. Of course, it's not going to give them carte blanche to install cameras or anything of that sort, at least not yet. But in terms of monitoring a computer or monitoring a cell phone, especially a company provided computer or company provided cell phone, that's going to be something that employers can do. So employees need to be aware of that and should actually, if necessary, get their employer to provide them with copies of those policies. Because those are regulations, as I say, that have sort of come into place or at least been amended or modified recently, specifically in the privacy context. There are other issues I think that remote workers face. It may not be from a regulatory standpoint, but a lot of remote workers think that they can simply remain working from home, when in fact there's nothing in writing that would allow them to work from home indefinitely. Even if it makes sense or you can do your job entirely from home and you've been doing it for the last 2 years, doesn't mean that you can insist on that arrangement staying put. And your employer does likely, in many cases at least, have the ability to ask you to come back into the office. And your employer can sort of regulate this based on the contract it has with you. So if you're an employee working remotely and you're being pressured to go back into the workplace, the physical workplace, I should say, don't automatically assume that you can push back and have the right to work from home for as long as you want. And you don't want to be communicating with your employer before you know all the ins and outs of these kinds of things. So this is another situation where I'd recommend that you call in if you're an employee being pressured to go back into the physical workspace. You've been working remotely from home. Give us a call so that before you say anything or communicate anything in writing to your employer that may hurt your ability to keep that job or potentially get severance, if that's applicable, you definitely want to give us a shout before you engage in any of that so we can sort of guide you appropriately and as I said before, intervene earlier if necessary. I've got another question in from Marwa on Facebook who's asking about what the rights of an employer is when they come to know that an employee is working, I guess, at the same time for 4 other organizations full time when they sign something saying they would only work for one employer. So that's a good question, Marwa. So this is on the side of the employer. If you have a contract with an employee and that contract says that they will only work for you, that they will devote their full-time energy and efforts to the business itself. This is something I see on a fairly regular basis. And you come to find out that they've now got 4 other jobs afterwards, or perhaps they had it beforehand as well. That would be technically a breach of contract. I think that if the contract does not speak to that, then the employee may technically be able to work in other organizations, ultimately provided they can do their job at the one you're talking about. But if you've got something in place that says they will only work for one and you find this out, that could very well be grounds for termination with cause. You could argue that it is an act of dishonesty, of course, aside from it being a breach of contract. And it's generally a bit more easier for employers to argue a just cause termination when it comes to allegations of dishonesty and breach of trust. Now, I will still say, and I've said this before, that it is very difficult for employers to establish just cause. And a lot of employers generally will still have to pay severance to employees that they want to let go. But as I say, in issues where there's a lack of trust and a breach of contract, you may have the ability to let this employee go and not be exposed really to any or very little liability on your end. But I think it'll come down to the documents that have been signed, the understanding maybe that was had between you and the employee. But it is a good question. It's a good situation. And I definitely recommend you also get in touch with us regarding this scenario so that we can kind of properly guide you throughout that too. I noticed that I'm sort of at my time for the day. I do appreciate everyone with their questions. Thank you as well as always. I will be back to answer more questions, but I do appreciate everyone's attendance today. As you see down below there, you can join us again live, 1 o'clock Pacific time. That's Tuesday, tomorrow, March 7 with Darren. So anyone who didn't have their questions answered or anyone who wants to ask a question, tune in then with Darren and he'll be happy to answer the questions at that time. But thanks again, everyone, for joining us. I do wish you well and have a great rest of your day. Thanks. Bye for now.